This hearing is in the matter CFI 051 of 2017 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Edward Knight. The defendant is represented by El-Tamimi & Co. Lead counsel is Rupert Reed, QC.
Thank you very much. Mr. Reed, do you want to kick off?
My Lord, this is the oral hearing of a renewed application for permission to appeal. The direction for the oral hearing is at page 55 of the bundle. I don't think we need to look at it. The court below denied, sorry, I should just say, I appear for OIC as the appellant. I'm assisted by Tim Killen in Australia and Rita Jabala, Peter Wood and Kareem Bassiso of Al-Tamimi. And Mr. Edward Knight attends for GMGHS as the respondent to the appeal. As your Lordship will be aware, the court below denied OIC permission to file a re-amended defence and counterclaim. That was sought both under RDC 18.2, the provision dealing with amendments, but also under RDC 21.8, dealing with counterclaims. My Lord, there's an immediate procedural issue, which is the role of Mr. Knight in this hearing. It's always a pleasure to hear Mr. Knight, but we may be setting a precedent in terms of his doing much more than attending and drawing to the court's attention, or keeping me on my toes and drawing to the court's attention if I say anything that's wrong or that may lead to the court. RDC 4414 provides specifically for the respondent to an appeal to put in written submissions in opposing permission to appeal. I don't think I've ever seen in practice a skeleton argument against permission to appeal. Ordinarily, the skeleton argument of the respondent goes in after permission has been given, if it's given. And the English convention is pretty clear that the respondent doesn't attend by counsel unless so directed by the court. I don't know if your Lordship has the white book to hand.
No.
I can refer you and read out very quickly the relevant provisions. They are to be found in Practice Direction 52C and at para 19 of 52C. It says respondent's actions when served with the appellant's notice. If the appellant seeks permission to appeal, a respondent is permitted and is encouraged within 14 days of service of the appellant's notice or skeleton argument, if later, to file and serve upon the appellant and any other respondent a brief statement of any reasons why permission should be refused in whole or in part. And there follows provision that should be no longer than 3 pages. So that essentially is the analogue of RDC 44.14. Allowing written submissions in opposition to an application for permission to appeal. Perhaps more pertinently for these purposes, paragraph 16 of Practice Direction 52, there is provision in the following terms. The court, dealing with the permission hearing, the court will notify the respondent of any oral hearing, but the respondent is not expected to attend unless the court so directs. There's also a note in the White Book, and that is, that's 52.5.2. I don't think I need to read that out because it largely summarises the provisions that I've just read out. I mean, it does also make clear that there are certain circumstances where a court hearing an oral application for permission to appeal may proceed essentially to hear the appeal, but that it cannot do so where the respondent is not present or is not attending by its counsel. So it adds that fact into the mix. But essentially, the position is, and my experience has always been, and I can't speak to your Lordship's experience or indeed your Lordship's, the appellate conventions that apply in the Scottish courts. But my experience has always been that insofar as a respondent attends a hearing, an oral hearing of an application for permission to appeal, the respondent by its counsel plays a minimal role, if at all, pursuant to direction, which is essentially to object if anything is said that is wrong or misleading. Of course, to some extent, it's helpful to have the Respondents' Council here because if Mr. Knight were not here, then I would be under an obligation, for example, arguably, to take the court to any contrary authorities or contrary documents. So the fact that he has already done that by way of his very helpful skeleton argument means that it's not for me because he's already taken the court to those documents and to those authorities. Well, Lord, that's all I intend to say.
Are you expecting some
rulings?
Some lucid guidance on this point, or is it better just to say, I note you what you say, but we are where we are?
Well, Mr. Knight's here. It may be that that we need to decide this issue and rule on this issue now. It may be that your lordship hears what I have to say in terms of the permission to appeal. I'm in your lordship's hands as to how your lordship.
Well,
but
I think the best thing is to hear your application. I'll take account of the points you make in deciding to what extent to ask Mr. Knight to help me. And but I don't think this is the right occasion to make some binding practice ruling, which will have an impact from now on for the future.
My lord, yes. There is obviously a danger that even without a ruling, one establishes a precedent.
That's the best practice. Anyway.
My lord, yes.
Yeah.
My lord, by way of a very brief background, there are two agreements in play in this case and on this appeal. They are signed by the same individuals and they're signed on the same date. That's the 13th of January 2015. There is firstly the MOU, the Memorandum of Understanding. That effects a joint venture between, on the one hand, of a subsidiary of the UAE insurance company, that's OIC, and on the other hand, the Lebanese healthcare business, Globemed, and indeed a company related to its chair and CEO. In essence, the MOU provided that OIC, the UAE group, was to take 51% of the shares in the joint venture company, which would be established in onshore Dubai. And those shares were to be held on trust by a UAE nominee.
Yeah.
And Globemed and a related entity was to take 49%. So it was to be, the Lebanese group was to be the minority shareholder in the joint venture company.
Yeah, yeah.
Layered on top of that memorandum of understanding, we have the TPA, the Third Party Administration Services Agreement. I'm just going to refer to it as the TPA. Your lordship will be familiar with this sort of agreement. It's fairly common in the region, for example, dealing with banking services where a foreign institution provides administrative services for banks or insurers, etc. This TPA was between, on the one hand, the joint venture company, which was GMGHS, which was to provide the administrative services to OIC. The effective date of that agreement was left in blank, and it was subject to a requirement that GMGS had the necessary licenses. I should say that's controversial. There's an issue about the extent to which that was a requirement or a condition. But in any event, it wasn't known when the licenses would be obtained, and we say that is why the date was left blank. It's alleged on behalf of Globemed clerical error. That essentially is where the difference lies.
Yeah.
GMGS's claim is under the TPA for wrongful termination, because before the agreement took effect, it was terminated. There's an issue as to whether that was wrongful termination. Now, OIC's defences under the TPA are firstly that GMGH wasn't licensed, didn't have the necessary licenses. Secondly, the TPA had not entered into effect. And thirdly, as a matter of UAE law, that loss of profits that are alleged by GMGS are not sufficiently certain. And your lordship may be aware of the fact that the requirement of certainty is far higher in UAE law than in most common law traditions. You can't recover loss of profits, which are generally considered to be too speculative or merely on the basis of probability. You have to show a degree of certainty, and that follows from provisions in the civil code that require damages, the relevant damages, to be the natural result of the harmful act. So those are defences that exist under the TPA. But there is also a prior defence which arises, we say, under the MOU, and that again arises as a matter of UAE law and as a matter of a very important rule of public policy and public order, which is that any UAE company must have a majority UAE shareholding. And indeed, that is enshrined in the early commercial companies laws, and it's also very clearly there in Article 10 of the 2015 commercial company law. And the consequences of violating that rule are that the relevant company is a nullity and that a third party is entitled to rely on that nullity in invalidating agreements by the null company.
Yeah.
Now, that defence is obviously, stating the obvious, is a complete defence, unlike, for example, the arguments about the certainty of any loss of profits, which may be defence. The nullity case is set out in the draft re-amended defence and counterclaim in green. It's possibly worth turning to that now.
Well, you can take, Mr. Reid, you can take it that I've read both the skeleton, the judgment, or both judgments of Sir Richard Field, and both skeletons. So I understand the shape of the case, and we can proceed upon the basis, can't we, that for present purposes, Sir Richard Field found that the proposed amendment raised an issue which was at least arguable. Whether or not it was likely to succeed, maybe a different matter, but at least arguable.
My Lord, yes, indeed, that it had real prospects of success.
Yeah.
Albeit that he considered that a marginal assessment. I do just wish to run, even if we don't go to the RADCC, just to run through the bones of the nullity case. Essentially, under Article 10 of the CCL, UAE partners must hold at least 51% of the shares, and that's pretty clear on the text of Article 10 of the relevant law. UAE law general looks through nominee or trustee arrangements. There's a certain industry that has grown up in terms of avoiding what we call the nationality requirement, the requirement of a majority UAE national holding, and one commonly sees this by way of nominee arrangements or side letters. And the approach taken by the UAE courts has been to look through those arrangements, which is essentially seen as seeking to avoid the prohibition. There is also a requirement in Article 23 that the members cannot waive or be deprived of their profit, or indeed their exposure to loss. So that's again essentially trying to block a means of avoiding the nationality requirement by having essentially shareholders who are nominal shareholders but don't actually have any exposure to loss or entitlement to profit. It's important to say that the issue of nullity is for the nationality requirement and the profit requirement are matters of public order, which has, as under the Civil Code, which has consequences in terms of their applying the nullity applying automatically and without the need for any declaration or order of the court. And it's important too to note that 16.2 of the Commercial Companies Law provides that a third party can request a nullity ruling, which has implications in terms of the personal liability of the promoters of the null company, but also in terms of the ability, we say, for that third party to have the company declared null. The consequence is obviously when one has a two-party contract of one of the parties being null, is that the contract, in this case the TPA, then becomes void, and that follows as a result of certain provisions of the civil code itself. Now there are 4 quick points to make in passing in relation to the nullity. First, as I've said, it is a complete defence, unlike the certainty of damage.
Mr. Reid, you're cracking up a bit. I don't know whether you're.
Can you hear me?
You become very hazy.
Can you hear me now?
What I'm going to do is put my ear.
Okay.
Hello.
Hello, my lord. Can you hear me now? Can you hear me?
No, your difficulty. Sorry. If you want to, shall I try and rejoin? Would that be the best thing?
Okay. Certainly, if that helps.
Can you hear me now?
I can hear you, my lord. Edward, can you hear me?
I can hear you, as you can tell from my reaction to when you speak. Yeah.
It's not working very well.
It's on.
I'll hopefully I'll read to you any better. I can hear you. I'm sorry about the lack of a picture, but it's what you say that matters, not what you look like.
I'm grateful. I was making a number of quick points about the number. I was observing that it is something that is it's a concept that's alien to many common lawyers. As a matter of Arab civil law, companies exist firstly as a matter of contract between partners, and so nullity arises fairly frequently and is a real issue in Arab civil law jurisdictions. But it's important too that because nullity is used to enforce various policy requirements. In this case, the nationality requirement. I.e. that 51% of the shareholders, or at least 51%, must be UAE nationals. Thirdly, I would observe that the nullity point, is a point entirely of law. It was argued before Justice Sir Richard Field in less than a day. Mr. Hellou's holding of shares was held on trust. There's very little doubt about that. It's clear on the face of the Memorandum of Understanding. And there is no, we say, substantial issue of fact and no substantial disclosure that would be required on any issue of fact. Fourthly, as your lordship has observed, the judge below found real prospects of success, and I see no challenge on the part of Mr. Knight in his skeleton argument against permission to appeal, suggesting that any challenge is made to that assessment by the judge below. Worth looking quickly at the MOU. The MOU is at page 320 in the appeal bundle. That's to say bundle A. If I could take your lordship there.
This is part of the problem. If I got no Wi-Fi at the moment, I can't bring up the appeal bundle. I've downloaded certain things, but not the full appeal bundle.
Okay. Well, perhaps I could read it out and give a reference for your lordship's note.
Yeah.
So in terms of reading it out, I'm reading from page 320 in bundle A, and if your lordship's using tabs, that's tab 4, subtab 23. The memorandum, as I've said, between Globemed, Karma Holding, a related company, and Synergize, which is an OIC subsidiary. And the important preamble says as follows: whereas Mr. Adel Ibrahim Al-Helou, a UAE national, owns 51% of the shares of GHS on behalf of Globemed, based on a side agreement signed between Globemed and Mr. Al-Helou, and the waiver of shares document signed by Mr. Helou in favour of Globemed, whereby Globemed owns effectively 91.05% of the shares in GMGS, and Karma Holdings through Munir Karma holds effectively 8.95% of the shares in GMGHS. So the idea of Globemed holding effectively 91.05% through including the shares held by Mr. Al-Helou, it's implicit in that we say that there is the trust arrangement, and indeed that is made explicit in clause 3 of the MOU, which refers to the partners. So it identifies A, Synergize being the OIC subsidiary, and then at B, the partners shall sign the necessary papers and perform the necessary actions to complete the sale of shares at the official authorities in UAE within a maximum period of 6 months as of the signature date of the present MOU. Globemed shall cause Mr. Adel Helou to sign all needed documents to effect the transfer of the shares he holds and in trust for Globemed to the investment entity, which is Synergize. And then the shareholding structure is set out below. So explicit reference to the shares being held in trust, explicit reference to their being held effectively or owned effectively by Globemed, and we say effectively means beneficially in that context, and explicit reference to the side agreement and to a waiver of shares document. So in terms of the application of the nullity principle, we say the relevant facts are indeed recited and rehearsed on the face of the MOU. And clearly there are legal issues, as you will have seen, considered by the judge below in terms of the application of Article 16(1), 2 and 3 of the Commercial Companies Law, and then indeed an argument raised by, in my learned friend's skeleton argument below, as to the arising of a de facto company, Harakat Muhassan. There are no, as we say, significant issues of fact, no significant evidence required. It is essentially a point of law. You will have seen it considered by the judge. You will have seen the skeleton of Mr. Knight below, in which the relevant legal points were taken. Now, in terms of the scope of the appeal, it is limited. You will have seen that there were a number of applications. My Lord, I see you've just joined the conference again. I don't know whether you've missed any what I've just said, or...
Can you hear me now?
I can hear.
I've got the picture from you about the shares being held in trust and so on, how that goes to fortify your argument about the nullity of the claimant company. Do I need more than that?
Well, my Lord, the further point clearly that it's a short, relatively short point of law, as you'll have seen it.
Well, yeah, I see that.
I'm grateful. I was just going to say that the scope of the appeal is relatively limited. You'll have seen there were 3 applications before Justice Sir Richard Field below. Firstly, the application to file the re-amended defence and counterclaim. And then there were 2 further applications, essentially strikeout applications, one by Globemed and one by GMGHS. The first against an additional claim, and the second against the setting off of that additional claim. So those 2 applications consumed quite a lot of the time. They raised quite complex legal issues in themselves, which is why, as I say, it was a relatively discrete legal issue below, and it would again be a relatively discrete issue raised on this appeal. My Lord, before we consider the individual grounds, I think we do need to look briefly at the procedural chronology, which applies across the grounds.
That's set out in your skeleton, yeah.
As set out, but I just wish to take points as we go through it. Firstly, the breach itself, the alleged breach, was in 2015. GMGHS did not, in fact, issue a claim until November of 2017, so there's a delay already of 2.5 years by GMGHS in bringing the claim. It then filed its amended particulars in May of 2018. Now, the first significant event is January 2019, the Dubai court claim seeking a declaration on the nullity issue. I probably can't take you to it, but I will give you, Your Lordship, the necessary references. They are at, it is at Bundle A, page 380, and the necessary references are between 382 and 385, which essentially sets out the nullity claim as it was advanced being advanced in the Dubai courts, and it is exactly the same claim that was then sought to be pleaded by the re-amended defence and counterclaim. And Your Lordship would see from the Dubai court claim that there was a significant team of UAE advocates who were involved in the formulation of that claim within Al-Tamimi, and clearly there's a significant amount of research and work that went into the formulation and pleading of that case in the Dubai courts. There is a finding of Justice Sir Richard Field in declining permission to appeal that there was a conscious decision not to plead the nullity issue. That's a rather odd formulation, and it's a finding that is made by reference to the 4th witness statement of Mr. Kishore for OIC. I'll give you the reference to Mr. Kishore's 4th statement. That is at A109. And if I could just read out a paragraph of that, that's to say paragraph 2. And this is expressly the paragraph to which Justice Sir Richard Field refers. paragraph 32, page 109, bundle A, OIC has many responses to these points. Firstly, the material period is since these DFC court proceedings began in November 2017. Second, as we've now explained to GMGHS, and as GHGS knows full well, OIC brought the nullification claim in the Dubai courts claim, which GMGHS opposed and which the JJC decision ultimately stopped. The nullification claim is a claim under UAE law against a UAE law company outside the DFC, and OIC took the view that the Dubai courts was the correct forum in which to bring that action. This is why the nullification claim was raised but not developed in the original defence. Following the JJC decision, OIC therefore had no alternative but to bring the same cause of action in the DFC court, which it is now doing. So that paragraph makes abundantly clear that the reason there was a decision taken not to plead the nullity issue in the DFC court proceedings was because there was a decision to plead the nullity issue in the Dubai courts. Now, you will have seen that the JJC took a view that was effected for the purpose of delay. Yeah. But the JJC were involved in a decision in allocating jurisdiction based on paper submissions without any hearing, without any relevant evidence, or indeed without any oral argument. And our concern in pursuing this appeal is that the judge has been swayed by the passing comments or obiter of the JJC and therefore considered both the Dubai court claim and the JJC application to be culpable. And that, we say, is a multifactorial or an evaluative assessment. It's not of itself a finding of fact. The finding of fact was that there was a conscious decision to plead the nullity issue in the Dubai courts. But as to whether that's abusive or culpable, we say that's an evaluative assessment, and that's obviously, we say, very relevant to the test that is applied.
Yep.
We do just want to highlight a flag at this point in the procedural chronology that in our submission, the Dubai court proceedings were entirely justifiable. GMG.
I've got that point. Yeah.
It's a UAE company. It's registered in the UAE. It's registered, in Dubai, and the Dubai courts are obviously better placed to decide the nullity issue, given their expertise, given their experience in that. Then in the procedural chronology, we come to the JJC application itself. So in February 2019, OIC applied to the JJC. Now, hello, my lord, can you still hear me? My lord, can you hear me?
Hello. I can hear you again now.
Ah, good. I was referring to the JJC. My lord, can you hear me?
Yes.
Good.
Yes.
I was referring to the JJC application made in February 2019 under Decree 19. I should say that final decisions are required under Decree 19 to be given within 30 working days. That's Article 3B of Decree 19. So, and I know the reality has now emerged in the 2020s that many of these applications can take a year or indeed sometimes more to be determined. That was far from clear back in early 2019. GM's case at the time, or its primary case, was that the DIFC court had jurisdiction over both issues, the contractual issues and the nullity issues. But in the alternative, it accepted, or it argued, that the Dubai court jurisdiction was restricted to the nullity issues. So its alternative case, it accepted that there may in fact be a proper allocation of issues. So the corporate nullity issue goes to the Dubai courts, which are the courts of registration of GMGHS, whereas the contractual issues arising out of the TPA go to the DIFC court pursuant to its opt-in jurisdiction.
Yeah.
If your lordship wants to look at that expression of the case in GM's argument to the JJC, that can be found at page 402 of the appeal bundle, tabs 5 and 31. And it's because the primary case was that the DIFC court, the Dubai court had no jurisdiction, that it was necessary to make the JJC application.
Can you just help me on this? I'm not as familiar as you are with all these matters, but could you not instead have simply brought it as by way of defence in the DIFC proceedings, and waited to see if someone took the point that it should be dealt with in the Dubai courts?
Well, that could have been done,
Yeah.
but we believed, OIC believed, that the appropriate court was the Dubai court, because it's an issue as to the nullity or validity of a Dubai company as registered in Dubai, and that I mean, arguably, what one could have done is we could have OIC could have sought a stay of the DIFC proceedings pending the decision as to the nullity or validity in the Dubai courts. Now, if Globemed had been willing to acknowledge that the Dubai courts had jurisdiction over the company, the nullity issue, then that would have been quite a sensible way of proceeding as a matter of case management. But because the primary case of Globemed was that the Dubai courts had no jurisdiction, the DIFC courts had jurisdiction over both issues, it follows from that that even if the Dubai court had ruled, the Globemed would have been urging the DIFC court not to recognise the judgment.
Yeah, I follow all this. Sorry, my question was the other way around, as to whether or not it would have been possible and therefore simply to ignore the Dubai courts, start it in the DIFC courts by raising a defence pleading the nullity issue, and then seeing if anyone objected. And if they didn't, then you'd have been further down the road before any problem arose.
Well, we could have seen whether Globemed objected to it being pleaded in the DIFC court. The issue was that OIC believed that the Dubai court was the appropriate court to be making that decision.
Yeah. Okay.
So that's why. But I think I accept that in terms of ideal case management, it would have perhaps the optimum solution would have been for the DIFC proceedings on the contractual issues to be stayed pending a determination of the Dubai courts on the corporate or the nullity issues. But that was never an option, precisely because Globemed, on its primary case, alleged that the Dubai court had no jurisdiction, and therefore any ruling obtained in the Dubai courts Globemed would have asserted should not be accorded recognition by the DIFC courts. And indeed, that's why we say the JJC application was necessary, because that's the function of the JJC, to allocate jurisdiction where there is jurisdictional conflict. I do think it's worth, if I may, very quickly reading the relevant paragraphs from the submission before the JJC of Globemed. I'm just going to read.
I think there must be a limit to what is relevant for this application. This is simply an application for leave to appeal against the substantive decision refusing to allow the amendment to be made. We take it as read for this purpose that Sir Richard Field found in your favour that there was a sufficiently arguable case on the merits of the point you wanted to raise by way of amendment. Do we need any more than that?
Well, my concern, my lord, is that we say what went wrong with the judgment below is that the judge focuses on an issue of culpability, and when one actually strips to its essence the suggestions of culpability, what the judge is actually complaining about is firstly the Dubai court claim. He says that was intended to delay and that was culpable.
Yeah.
And secondly, the JJC application was culpable on the same basis. Yeah. And indeed, all roads seem to follow back to that. So he says, for example, well, there's potential prejudice to third parties and other court users, but one sees that is precisely by reference to the JJC application, which required the vacation of the trial date. So again, everything leads back to the Dubai court's proceedings and the J. So it is quite important just to make the point, and I'll make it briefly without going into document, but I will give you the page number. It's page 418, paragraphs 41 to 42, and paragraph 45C of Globemed's submissions to the JJC. that in those submissions they accept as their alternative case that the Dubai court should have jurisdiction over the corporate nullity issue, and the DIFC court should have jurisdiction over the over the contractual issues arising consequentially under the TPA. So their alternative case sought to protect the DIFC jurisdiction over the contractual issues, which we accept. And so in terms of the view then taken by the judge that this is all an abusive, culpable, a contrived attempt to delay and to waste time in circumstances where the nullity issue is clearly set out in the Dubai court claim. There is a good reason for bringing it in the Dubai court, and there is a necessity to make the JJC application in circumstances where it was not accepted by Globemed that the Dubai court had jurisdiction over the nullity issue. In those circumstances, we say the judge was wrong to take into account, was wrong in his assessment of culpability, his evaluative assessment of culpability, and was wrong then to take that into account in terms of whether he should allow the amendment. There is a further period of alleged culpable delay. It seems to weigh less in the judge's consideration, but it's important nonetheless. That's the application for security for costs, which was made the 30th of October 2019. Now, there were very significant costs being incurred at this point, not least ongoing disclosure issues, and threats were being made by Globemed to seek an unless order. Those threats were ultimately abandoned. But OIC clearly had the intention to amend its defence to add the nullity issue. I mean, that, after all, is the logical consequence of the finding of the JJC that actually the DIFC court had jurisdiction both over the corporate issue and over the contractual issue. And indeed, that's part of the submissions made by Globemed, that it would need to be properly pleaded in the DIFC court if it was to be pursued. But we say, given that that OIC was intended to do a lot of work in terms of amending its defence, adding an additional claim, pleading the set-off between the additional claim and the main claim, it's unsurprising that there was a hiatus whilst the security for costs was resolved. After all, it's no point incurring the cost before the security for costs has been put in place. It was anticipated that security for costs could be agreed relatively quickly. The reality was that...
Mr. Reid, again, I'm sorry to cut you short. I've seen the point in the skeleton, but it seems to me that a party who wants to raise what it thinks is a fundamental defence and amend it into its pleadings may have to take the risk on costs, that you just get on with it. You didn't have to wait until the security for cost application was dealt with. You could have gone straight in after the JJC decision and sought to amend at that stage.
We could have, as I've said, these were the very costs for which we were seeking security. OIC had been seeking it since January of 2019. A spirited opposition was being put up by Globemed, which was arguing there was no obligation to provide any security. The initial position was one of complete refusal. And I should say what then followed was an allegation that, an offer of a promissory note from the Lebanese parent entity, so no security at all. So at this stage, OIC was dealing with what appeared to be a rather abusive response. Firstly, in refusing an obligation to provide security, but then in offering security, which was entirely would have been of no effect. And it was only on the 21st of January 2020 that Globemed agreed to provide a UA bank guarantee and to pay OIC's costs of that application. So there is some, as you'll see in the skeleton, some effective admission that they should have provided security, and they should have done so earlier. And I should say, even at that stage, there was provision that for some time, for some months, I think until March, for the security to be put in place. And indeed, the stay, an effective stay, was accepted, because if one looks at the draft order, it provides for the security to be provided by March, and nothing is to happen until after a certain number of days from the date in which that security is provided, which is referred to as the provision date. So witness statements are to be a certain number of weeks after the provision date. So indeed, at that stage, in terms of the order that was agreed, Globemed were in effect agreeing to a stay subject to when they were able to put in place effective security. So at that stage, it was an implicit assumption that until security had been by OIC, until security had been agreed, and by Globemed that until it had been put in effect or provided, matters would in effect be stayed. At all times, the implication, the nature of the amendments was entirely clear. That was, they were intimated by a letter of the 30th of October 2019. And for your Lordship's notes, that's page 447 to 448 of the appeal bundle. They were the draft RADC was served in January of 2020. I should just say that even in October, and if I can quickly read out a communication in October of 2020, and it's in bundle C at page 2284.
Mm-hmm. Yeah.
Sorry, just let me find it. So this is an email from Clyde & Co. Of the 18th of November. Sorry, it's November 2019. But it says in the course of that email from Clyde & Co. To Al-Tamimi, the defendant has not provided the defendant with a copy of the proposed amendment pleading, despite the defendant first raising its intention to seek the defendant's consent over 2 weeks ago. Given the proceedings filed before the Dubai courts, it's reasonable to assume, in the absence of a draft amended pleading, that the amendments proposed will address the same issues raised before the Dubai courts. In such circumstances, we note that the defendant has conveniently failed to provide any explanations to why those arguments filed before the Dubai courts require further consideration in order for the amended defence to be prepared. So OIC was, Globemed was entirely aware of what would be in the re-amended defence and counterclaim. There was no surprise at all in what was pleaded. The registry directed that an application for permission to amend should be made by the 30th of January 2020, and that is precisely what happened. The OIC filed its application in accordance with the direction of the registry. That's all I think I need to say in respect of the procedural chronology. The legal test on an application for permission to appeal will be well known. There's the first limb, obviously, that there needs to be a real prospect of success. That's under 1419(1). And there's an alternative ground where there be some other compelling reason. Now, we would say under limb 2, 4419, that there are other compelling reasons. This is a very high value claim, 36.5 million. What OIC has been prevented from pleading is a complete defence to that claim. It's a defence which has been found and accepted by the court to have real prospects. And OIC has been deprived of an opportunity of taking that case, that defence, to trial. It's possibly worth looking at one authority, one recent authority in respect of appeals on this sort of issue. It's the fixed sense management case. I will, bearing in mind that your Lordship can't refer to it, is in bundle B at page 26, tabs 1.5. It's a decision of the 13th of June 2021 by the Chief Justice, refusing permission to appeal against a decision refusing immediate judgment. And essentially the court reaffirmed the Skurikin principles and found that disputes of fact should generally go for trial. But it also found that issues involving public policy would also require full argument and should go for argument at trial. And it raised specifically an issue as to the foreign ownership of UAE companies and the application of the Commercial Companies Law. So there again, a related issue in respect to foreign ownership and the application of the Commercial Companies Law applied, and the Chief Justice found that that issue of public policy required a full argument at trial. Also relevant is a postscript by the judge. And he said that the court should be slow to give permission to appeal against an order where the aggrieved party has an opportunity at trial to advance its case. But he also made clear the converse, and this is at paragraph 2 of that postscript, that is unlike where the defence is struck out. And he said, and I quote, an order striking out a claim or defence gives finality to the case, and courts should be sympathetic and readier to grant permission to appeal. So where there is a decision that prevents a party taking an argument to trial, because it has finality, the court should in those circumstances be sympathetic and readier to grant permission to appeal. So that's an interesting new gloss, if you like, on the test that arises under 44.19.1. As for the legal test on the appeal itself, that's provided in RDC 44.117. The decision of the lower court must be wrong or unjust because of serious procedural or other irregularity. I should just say there has been authority, and this is summarized in 44.117.2 of the DIC practice. And that is the effect, the decision of the Court of Appeal in the IGPL matter, that the court should not gloss 44.117. And in that case, the court rejected submissions based on English cases that wrong applied only to issues of law. Wrong can equally apply to issues of fact. And obviously, the other gloss that is commonly applied is the suggestion that it must be plainly wrong. What is clear is that from that decision is that RDC 44.117 can be read for what it says. We are in any event dealing with an appeal against a discretion and or a multifactorial or an evaluative assessment. And there's plenty of case law to the effect that where you're deciding, for example, whether something is an abuse, that is an evaluative assessment. And indeed, it's probably more than an evaluative assessment that is the exercise of discretion, insofar as there may be some discretion that arises from the fact of from the assessment of an abuse. Now, the circumstances that apply, or the requirements of an appeal against discretion or an evaluative assessment, are that the judge has misdirected himself or herself, left relevant factors out of account, taken irrelevant factors into account, or taken a decision which is outside the range of conclusions reasonably available. And that gives rise to the necessary inference of error. If your lordship needs the English authority for that, that's the job.
No, it's too well known.
Too well known. Good. There are, as your lordship will have seen, 3 grounds of appeal. Firstly, the failure to properly effect balance of prejudice. And that, we say, is both a misdirection and something that is plainly wrong. It's in being outside the range of conclusions reasonably open to the judge on that balancing. Second, there is a failure to distinguish a proper approach to the late and very late application distinction. In effect, we say the judge misdirected himself on that. And thirdly, we say there's a failure to accord proper weight to the various reasons for delay. Certainly in terms of the issues, as an issue as to what was taken into account. Your lordship has kindly indicated that you have read the judge's reasons. Therefore, I'm happy to go through those and look at them in detail. Essentially, they start at paragraph 41 of his decision, where he identifies what it is that OIC needs to show, and he sets out the case in terms of real prospects of success, and then B, suitable case for the exercise of the court's discretion. It's important that he identifies those as A and B, because he later explains that insofar as there's an application to withdraw a concession, albeit that is a separate application, which he finds to have been made implicitly, he considers that application as well as the application to amend by reference to the factors in A, the circumstances in A and B. That's to say whether the case has a real prospect of success and whether it's a suitable case for the exercise of the court's discretion. The judge then considers the relevant circumstances. He starts by identifying that he needs to consider the impact of granting permission on GMGHS and the impact of refusing it on OIC. So he, if you like, recites or nods to the balance of prejudice. He acknowledges it. But we say he then fails to apply it. There is no consideration, on the one hand, of the impact of granting it on GMGHS, which we say would be relatively minimal, and on the other hand, the impact of refusing it on OIC, which is very significant, we say, given that it would provide a complete defence to a very substantial claim. The judge, in providing his list of considerations, then refers to delay in bringing forward the new case and an explanation as to why it's not pleaded at the outset. These are considerations that are commonly raised in respect of applications that are said to have been made very late. They are, if you like, additions to the sort of historical test, which was very much concerned with ensuring that the relevant issues were before the court, save insofar as they were capable of being compensated in costs. This new raft of considerations in terms of requiring an explanation for delay is part of the case law that arises out of very late applications. Then the judge refers to the overriding objective under RDC 1.6, which is there to enable the court to deal with cases justly. He enumerates a number of factors which we say weigh in favour of OIC. So he asks whether the case is dealt with in ways that are proportionate. Well, proportionality clearly refers to the value, the amounts in issue in case, and we say there are very significant amounts in issue given the quantum of the damages claim being made by GMGHS. The court needs to consider the amount of money involved, the importance of the case, the financial position of each party. And there's no suggestion that either side will struggle to make or defend these very significant claims. The court must also consider the complexity of the issue. And in fact, in this case, the issue, albeit that my learned friend makes much of the fact that it is pleaded in 4.5 pages, the reality is the short points are relatively discrete and indeed were dealt with both by the judge below and indeed by my learned friend in his skeleton below in 15 or 16 paragraphs. It's a relatively discrete legal point that can be, we say, argued relatively quickly. Certainly less than a day would add less than a day to trial. It's very much an argument as to the effect of Article 16 of the Commercial Companies Act and indeed the consequences of it being alleged that a de facto company then arises to fill the void left by the null company. Then at paragraph 64 and 65, the judge deals with the implied application to withdraw an admission, and he says that in this case the focus will be on A and B, and that's 41A and B, so real prospect of success, suitable case for exercise of the court's discretion. So significantly for our purposes, there is no separate consideration required in respect of the withdrawal of an admission. It's done by reference to the same test. In paragraph 66, he considers the exercise of the discretion against the grant of permission, and the judge identifies a number of circumstances. Firstly, he says OIC has had 3 years to consider its defences. Well, that may have been true, but in fact it was only 1 year from the claim. He includes within the 3 years the 2 years that were taken by the claimant to bring its claim at all in any court. Secondly, the judge says there was a conscious decision not to plead the nullity point. Well, I think I've explained. The conscious decision was that the nullity point should be pursued in the Dubai courts as the correct forum. And that, we say, is not abusive. It's not a culpable. It's a perfectly legitimate position to have been taken. And indeed, it accords with, consistent with the alternative case taken by GMGHS in its response to the JJC application. Thirdly, the judge considered the delay of a year before the Dubai court proceedings were brought. And I think, my lord, on that we have to accept that there was a delay between January 2018 and January 2019. We do, however, say that that delay was historic. It arose as a result of the rather unwieldy procedures by which that claim had to be considered and formulated and pleaded. We accept that it was a delay, but it was historic. And in terms of the case management being considered by the judge on this application to amend the RADCC, the case management issue should have been focused in our submission on the present, on the now, on getting this case to trial and the implications of permitting the amendment in terms of getting the case to trial from that point on. The historic delays are not relevant as a matter of case management. They may, on the judge's view, have been relevant as a matter of culpability, but as your lordship will appreciate, in our submission, the assessment of culpability is fundamentally wrong. The fourth consideration is the stay for 10 months pending the JJC application. And well, of that, clearly, the delay is caused in large part by the failure of the JJC between, I think, June and October to communicate its decision. It wasn't certain that such a delay would arise. Indeed, as I said, 30 working days is the period in which a determination is supposed to have been given. And insofar as what is criticised is the making of an application to the JJC in our submission, there is nothing unjustified, nothing culpable, and nothing abusive about that decision to apply to the very committee that is intended to allocate jurisdiction as between the Dubai courts and the DIFC courts. And fifthly and lastly, it was said by the judge in paragraph 66 that the trial date had been lost. Now, so this was effectively the first serious trial date. I think it was initial trial date set very early, but this was the first serious trial date set. That was on the 22nd of September 2019. And I understand that around the time the JJC application was made, that trial date was vacated. But it was vacated, we say, 8 months before the trial date. And therefore, in terms of likely prejudice to third-party court users, it's very unlikely there was any prejudice. Clearly, if a trial date is vacated shortly before trial, there may be a judge sitting unoccupied when he or she could be hearing other cases and serving other court users. But that doesn't arise where a hearing date or a trial date is vacated many months before, because clearly matters can be rearranged.
Yeah.
So we say that the evaluative assessment of the judge that there was culpable delay, and therefore on that basis it is unfair to permit a new claim. We say the logic of, well, firstly the evaluation itself, the assessment has gone wrong, but also the logic between culpable delay and unfairness in permitting a new claim simply doesn't follow. This paragraph 67 of the judgment offers essentially recaps on what has been said, but also says that there has been an unexplained omission to plead the nullity issue. Now, that we simply do not understand how that can be said. The nullity issue was not pleaded because it was being presented in the Dubai courts, and we've explained, and we explained below, why that decision was taken, and we explained that it was consistent with the alternative case of Globemed in the JJC proceedings, and it followed from the pleading in the Dubai court that the JJC application was likely, and that there was therefore likely to be a short stay. But in our submission, the conclusion of the judge that it was then culpable and therefore unfair for OIC to plead the nullity claim, which is an assessment based on a number of factors, in our submission is simply wrong. The paragraph 68, the judge deals with the allotting appropriate share of court resources, the impact on other proceedings. I think I've explained why, firstly, that the vacation of the relevant trial date was historic, and clearly we say the focus should be on, the court should be on ensuring that a current trial date is maintained, and there is no current trial date. And indeed, that, we say, is the reason for the law that has developed in respect of very late applications where a current trial date risks being vacated and risks being lost.
Yeah.
And then paragraph 69, there is the issue of culpable delay. That is after the 23rd of, that's after the JJC decision has been communicated. And the judge took the view that there was no justification for OIC essentially pausing until the security for costs had been agreed.
Yeah.
But it was, but interestingly, he did so on the basis that it was obvious from the outset that GMGHS would have to provide security. Now, that assessment, again, we say makes little sense. Indeed, reliance has been put, even in my learned friend's most recent skeleton, the skeleton against permission to appeal, on RDC 25.107, which says that an application for security should not be made later than at the CMC, which is impliedly the first CMC. So the application for security on the analysis on the provision in 25.107 was late, was out of time. And that was indeed the basis of the refusal by Globemed to make any offer initially of security for costs. So it was far from obvious at the outset that security would have to be provided. It's far from obvious, therefore, that OIC should press on the basis that, well, obviously security is going to be agreed or ordered in the end of the day. OIC would, in effect, have been taking a very significant risk in incurring significant costs without security being in place, in circumstances where Globemed was insistently denying that there was any entitlement to security. And indeed, it's interesting that in RDC 2512, there is a suggestion that it's better sometimes for the claimant to have a reasonable period to provide security. So the RDC, and perhaps it's worth just looking at that quickly, that's RDC 25112.
Mm-hmm.
I don't know if your lordship has that in paper.
Yeah, yes, I have it. Yeah.
So it's not usually convenient or appropriate to order an automatic stay of proceedings pending the provision of security. It leads to delay and may disrupt the preparation of the case for trial or other hearing. Experience has shown that it's usually better to give the claimant or other relevant parties a reasonable time within which to provide the security and other party permission to apply to the court in the event of default. This enables the court to allow the claimant to choose if he wishes to provide the security, and if he does, to dismiss the case. So that procedural guidance in RDC 25.112 does seem to suggest that although there shouldn't be an automatic stay pending the provision of security, it may be reasonable in circumstances for there to be such a stay, and indeed a stay, firstly to allow the issue as to whether security should be provided to be resolved, but also to a period for the security itself to be provided. And that indeed has been the experience in this case, that once it was agreed in January 2020 that security would be provided, it was then going to take a further period of up to 3 months, and indeed it appears it has taken much longer than that, 3 months in which to put the security in place by way of the necessary arrangements with a bank or financial institution in the UAE. And indeed, we would draw attention to the fact that most of the delay in our submission is due to GMGHS essentially attempting to try it on by, for example, offering a promissory note from a parent company in Lebanon, which clearly in our submission would not be.
Mr. Reid, I've noted these points. It doesn't provide an answer. You may have criticisms to make, but it doesn't provide an answer as to why you didn't just get on with it.
Well,
given that you're starting late.
Well, my lords.
But I mean, we've been around this point already, I think.
Lord, yes. my primary argument against that would be that we are still essentially dealing with a balance of prejudice. We are still essentially saying that insofar as there was a delay, for example, in seeking seeking security for costs, that and indeed for delaying the application to amend whilst security was being obtained, when one weighs that against the prejudice to OIC in terms of having a complete defence to a very significant claim being denied, it being shut out of making that defence, the balance of prejudice weighs very significantly in OIC's favour. And the exercise that we say the judge should have carried out, beyond merely acknowledging that there needs to be a balance of prejudice, is in considering firstly the minimal inconvenience that would have arisen to GMGHS if permission had been granted. And we've made the point thus far about the minimal additional time. Essentially, an additional day of trial time would be needed. And one sees that from the length of the section of the judgment in which that is the substantive case is considered. And we've looked at the legal argument essentially arising by reference to Article 16 and the suggestion of a de facto company arising. Your Lordship will be aware of the international approach taken by the DIC Court pursuant to Vidal and Felicia. So there's no presumption of the English approach where these issues of UA law would ordinarily require to be dealt with by way of, as issues of fact, by way of expert evidence. If your Lordship needs further understanding of that, that is set out in the Dubai practice at note 31.12.2. So there's a preference, particularly dealing with UAE law, for the international approach, particularly given the experience of DIC judges, particularly in the Civil Code, the Civil Procedure Code, and the Commercial Companies Law. These are three statutes that are well known to most DIC judges, and indeed a certain number of judges have expertise in these by reason of being UAE trained and qualified themselves. And indeed, this very approach was demonstrated by Justice Sir Richard Field himself in finding that there was a real prospect of success, and considering that argument on the basis, indeed, of what was largely of what was said in Mr. Knight's skeleton argument. Now, at the time, the trial date was not set, so the only prejudice would be, as I say, an extra day of trial. There was no vacation of any existing trial date. And in those circumstances, we say that in terms of the prejudice to GMGHS of the permission being granted, it is, in our submission, very light in the scales of that balancing exercise. And one has to set against that the prejudice to OIC if the permission is refused, and the court, not least in circumstances where the court has found the defence to have real prospects. In crude economic terms, even a 50% chance of of complete defence to a $36 million claim has an economic value of $18 million. And one can see, therefore, why Globemed would be so keen to see off any appeal at the pass, and indeed why Mr. Knight was filing a skeleton argument against even permission to appeal. Globemed believes that it has a real chance of claiming the entire projected profit of the joint venture. And you'll see that from the discussion in the judgment of the fact that the additional claim has been prevented. So essentially, even though it was only supposed to be a minority shareholder in the joint venture company, because it still holds the shares in all of the shares in the joint venture company, it is claiming the entire projected profits of the joint venture. So it already has that. What it further claims, and this I should say is a claim, this is a claim which the JJC ordered the Dubai court, its claim is a claim which the Dubai court was ordered to cease entertaining on the very basis that the DIFC court had jurisdiction. So even, and I should say that is a case which GMGHS acknowledged in the alternative could be determined by the Dubai court. So to lose that defence, which is economically and legally so significant, which it was ordered by the JJC to the Dubai court was ordered by the JJC not to entertain, on the basis that on the DFC court had jurisdiction and could entertain. There's therefore an element of a double coup, if you like, for Globemed, entitled to all of the profits of the joint venture, but also a claim that it's persuaded the JJC to disclaim from the Dubai court on the basis that the DFC court has jurisdiction. Effectively, Globemed would then have had a nullity claim removed from both courts without that defence, that counterclaim, even being decided, or rather, insofar as it is decided, being found to have had real prospects. And all of that to occur in the name of fairness in our submission is pretty extraordinary. Globemed's response on that first ground is to say, firstly, that the balance of prejudice was a fundamental basis of his decision. But the reality when one reads that decision is that nowhere is there any assessment of the prejudice from the perspective of each of the parties, of each potential outcome. There is merely a reference in that paragraph to the necessity of that balancing exercise. But what does appear to be a fundamental basis, or central to the reasoning of the judge below, is an assumption that the JJC application and the resulting delay were in some way culpable on the part of OIC, and that that requires a necessary conclusion that it would therefore be unfair to permit the amendment. It is the lack of a logical connection between, firstly, the assessment of culpability, which we say is wrong, but also the alleged consequence that it would be unfair to permit amendment that we find especially striking. The only explanation, the only logical link between the alleged culpability and the proposed unfairness suggests that the refusal has some sort of punitive quality, that it should be exemplary in some way to parties, that if they indulge in culpable applications to the Dubai Court or the JJC, that they may then be prevented from bringing the relevant case in the DIFC court. And that punitive element cannot be recharacterized as a reasonable balancing exercise. It is not, in our submission, within the bounds within which a reasonable disagreement is possible, within a test that applies to the exercise of discretion or an assessment. The second part of the response by GM in its skeleton argument against permission to appeal is that OIC is in some way seeking to go behind the judge's findings. Well, as I've suggested in our submission, issues of culpability and abuse are evaluative assessments. They are multifactorial, requiring the consideration of facts and legal definitions or terms of art in terms of culpability or abuse. It's sometimes said that a decision based on an evaluation isn't really the exercise of a discretion. It is more, as I say, an evaluative assessment in itself. And on that basis, it's suggested it's more susceptible to having an obviously right answer. And we would certainly say that in respect of the core assertion by the judge below, pursuant to the observations of the JJC, that the behaviour of OIC was in some way, in bringing the Dubai court claims and in bringing the JJC application, was itself culpable, which is, as we say, is not an effectuation of the balancing exercise. It is simply an attempt to punish OIC for behaviour that is identified, historic behaviour that has been identified by the judge as being culpable or abusive. Thirdly, it's said by GM that there would be an impact on the trial date. The immediate focus of that submission is then on the loss of the 2019 trial date, which we say is entirely historical and therefore relevant only to the culpability analysis. It's not, or it should not, be a material consideration in terms of case management now, Insofar as the RCMC, the reconvened case management conference, was vacated in January 2020, that was because GMGHS had conceded security for costs. It was not because of the application for permission for the RADCC. And lastly, it's said by GM that there would be significant additional work and cost if the permission were to be granted, or permission to appeal were to be given, and permission ultimately to be granted. Well, as we've said, the issues of UA law are difficult, but they are discrete. They are dealt with in 15 paragraphs in terms of the merits assessment by the judge on the application below. And nowhere do we see from GHS any sort of explanation as to what additional time or cost could be required beyond that of a day of legal argument at trial. Now, the second ground is that the judge misdirected himself in proceeding on the basis of a very late amendment. Your Lordship will have seen in the skeletons some discussion of the Kwa Su Ling decision of the Commercial Court, I think in 2016. That's at Bundle B at page 185. It's still the leading authority on very late amendments. I would wish to draw Your Lordship's attention to just 4 subparagraphs of that. Paragraph 38A makes clear that the starting point remains the balance of prejudice, or injustice as the court refers to it. Behind that, it's clear that the old law is still being considered, so the court still has to consider that an amendment should, in general, be allowed so that the real dispute can be adjudicated. That seems to be consistent with the balance of prejudice, or considered in the same analysis. And then in paragraph 38B, the court deals with very late applications, and in those circumstances, the court may depart from a balancing exercise in according a heavy loading of the balance or a heavy burden on the applicant. But that's precisely because of the risk of prejudice to other court users. And that itself feeds into 38C, which defines a very late amendment in terms of where the trial date is fixed and where there's a risk of the loss of the trial date. And I should say that in 38D, there is reference to lateness being relative and some suggestion, therefore, of a spectrum. But it's absolutely clear in our submission that there should only be a heavy loading of the balance where there is a very late application which puts in jeopardy an existing trial date. And that simply is not the case in this case. There was no trial date. There still is no trial date. And in those circumstances, it wasn't a very late. There should be no significant loading of the balance if indeed the judge had carried out the balancing exercise in terms of considering specifically the prejudice, the risk of prejudice to both parties. We do refer in our skeleton 2 to the Ahmed case, which is an example of where an amendment is allowed. And in that case, the amendment was allowed even during trial. And that was allowed, essentially an allegation was made during trial that the will had been forged. And the judge considered that the defendant was not in the slightest bit taken by surprise by that argument.
I've seen that in your skeleton, yeah.
And we say that's exactly the same in our case. And I've taken your lordship to the email where they say, well, clearly what you are going to be arguing in your amendment is what was argued in the Dubai courts, because the Dubai courts, the JJC essentially said that this point needs to be taken in the DRC court, not the Dubai court. So this court is on all fours in terms of an amendment being allowed, in that case even later, by reason of the fact that no one was taken by surprise by it. And we say, if, contrary to what we have said, a heavy burden is to be applied more broadly than Kwa Su Ling suggests, that would be a procedural decision that would merit serious consideration by the Court of Appeal, and that would be in itself a proper basis for granting permission to appeal. We are very aware, and we accepted before the judge, that matters have moved on from the days of Cobbled and the London Borough of Greenwich, the 1999 decision in which the Court of Appeal said that an amendment in general ought to be allowed so that real dispute can be adjudicated, provided that any prejudice can be compensating costs. We accept that is no longer the position. But insofar as there should be any heavy burden on the applicant, or indeed any heavy loading of the balances, that should be reserved in our submission to the very specific circumstances that are identified in the Kwasu Ling decision.
Yeah.
One moment, my Lord, see if I can cut out. Yes, just in terms of delay and what has been said in terms of it being a relative issue, we say any culpability is relatively minor. There's an early delay between 2018 and 2019 of a year in terms of bringing the Dubai court proceedings. There are some months of delay whilst the application proceeds for security for costs. But all of the other periods of delay in our submission have good explanations. And in our submission, nothing like the degree of culpability that would be required to deprive the defendant of a defence to a $36 million claim. And I've explored what could have happened in terms of staying the DIC court proceedings pending the Dubai court proceedings. That is something that wouldn't have worked given the position that Globemed were taking at the time. Similarly, in terms of the security for costs, the OIC could have sought a stay of the DIC court proceedings, and there's some suggestion in that note that indeed the court may have allowed an application for a stay. So in those circumstances, if OIC is to be punished for a delay in bringing forward its amendments whilst security was being resolved, any culpability was in not formally seeking a stay, where in circumstances where it's likely that a stay may have been granted. Now, it's easy with the benefit of hindsight to establish a degree of fault in respect of, firstly, the Dubai court proceedings and the failure to advance the amendments whilst seeking security for costs. But in our submission, there is an explanation, and any degree of fault is a long way, is a country mile from the degree of culpability that would be required to essentially apply the test that is applied in English law in respect of very late amendments. A delay generally in terms of English case law is relevant only insofar as it affects the disposal going forward, future disposal of proceedings. That much is true too of DIFC law, and we refer in our schedule to the L.L.C against Sunset Hospitality case at paragraph 27. That's in bundle B at page 15, and the relevant paragraph 27 is at page 22. And the court made clear in that decision that delay is just one of many factors to be considered. And as I say, our primary case in respect of ground 2 is that this is not a case of a very late amendment. The delay that has arisen is not going to have an effect on proceedings going forward. And indeed, in the L.L.C decision itself, there was discussion of the fact that there was no. Sorry, I'm maybe confusing, but there was, I believe, there was discussion of the fact that, and I may be thinking of the wrong case, but the fact that the trial date in that case was not in fact set, and there was therefore no potential jeopardizing of a trial date. And what the court should not be doing, considering delay, is seeking to assess culpability for past delay.
Well, I have this point, yeah.
My Lord, the third ground is that factors were taken into account which should not have been, or were not taken into account which should have been. Yeah. And we say that those factors were part of the evaluative assessment. They were not, on any analysis, findings of fact. I will deal with them quickly because I've dealt with them substantially already.
They cover many of the same points you've already dealt with.
OIC was wrong to issue the Dubai court claim, wrong to make the application to the JGC, wrong to pause while obtaining security for costs. And clearly what is said by Globemed is that there's no explanation for the delays. Well, I hope from what I've said, your Lordship will appreciate there is in our submission a good explanation for most of the delays, and what remains are far from sufficient to require a heavy loading of the balance. I think you have, in terms of the issue of the Dubai court claim, it was a defence that's been recognised to have real prospects. The judges had the relevant expertise. There was no necessary conflict of jurisdiction, in our submission, given the potential allocation of jurisdiction between the two courts. The neater solution may have been to apply for a stay of the DFC court proceedings, but that was prevented in our submission by Globemed's primary case, and there was no culpability in our submission in making the Dubai court, pursuing the Dubai court proceedings. As for the JJC, again, we say there is no culpability. It's implicit in OIC's position that if the nullity claim succeeded in the Dubai courts, the contractual claim would then have been dealt with in the DFC courts. GMGHS itself accepted on the alternative basis that the...
Well, I've had this now quite a few times.
And I don't think I need to make a point about a stay being relatively brief, and therefore the impact should have been minimal in respect of other court users. And thirdly, the delay pending security costs. I think I've made my points on that. And we say a substantial part of that delay was in fact the failures on Globemed's part to engage with the application, firstly in refusing security, but also in offering Lebanese parent guarantees rather than real security in the UAE. And indeed, a degree of responsibility of that delay was accepted by GMGHS in agreeing to pay OIC's costs. So all of these considerations are taken out of account, and we say applying a proper balance of prejudice, it's clear that the amendment not only has real prospects of success, not only would require only a day of legal argument, but should, in our submission, be allowed. And in our submission, the balancing exercise, the proper balancing exercise, has been distorted by a disapproval of the JJC application. But that is there is no proper basis for the judge to have simply followed the JJC's obiter criticism of that decision. And we fear that the balancing exercise is therefore being used to disapprove of an application to the JJC, because without that factor, without that assessment of culpability, the existing balancing exercise cannot, in our submission, be made to stand up. And on that basis, we say there's a real prospect that the appeal would succeed. It's not, the permission process is designed as a filter to filter out hopeless cases. This is a case that has real prospects, and on that basis, the permission application should be granted.
Thank you very much. Now, Mr. Knight, you're here, and I'm not going to make any ruling as to whether you should be here. Do you want to say anything? I've read your skeleton. Is there anything you want to say, but briefly, is there any point that you haven't covered in your skeleton?
My lord, my skeleton, I think, almost fully deals with the points made by my learned friend. And obviously, I would draw your attention in particular to the Essex County Council case, which I've quoted from and is in the bundle in respect to the test applicable to the late and very late amendments. I've set it all out in my skeleton argument, and I won't go through it again here. What I'm more concerned about is a couple of the submissions that my learned friend makes, which don't form part of the grounds of appeal. He's relied heavily on there being other compelling reason in the importance of public policy with relation to Dubai and foreign ownership of companies and trusts, etc. I just want to make the point that that is not part of the grounds of appeal. It was not a submission before the judge at first instance that there was another compelling reason to put the matter off for trial. It wasn't argued before him. It's not in the grounds, and nor is it in the skeleton. It was hinted at, I accept, in the reasons that there should be an oral hearing of this application, but it is still not part of the grounds of appeal. My Lord, the other matter is in relation to culpability. Again, my learned friend has just said towards the end of his submissions that the judge was wrong in imputing culpability to OIC. That is not part of the grounds of appeal. There is no suggestion that the judge was wrong in making those findings. What they've done is simply assume the contrary to support their case. For example, at 1.3.1 of the grounds of appeal, it simply said that the learned judge failed to accord proper and appropriate weight, or failed to take proper account of, the fact that the decision by OIC to issue the nullity claim in the Dubai courts was a reasonable decision.
Well,
that's
saying in more polite words that he was wrong to treat it as culpable.
Well, if they say that he is wrong to treat it as culpable, they must find reasons why he is wrong.
Well, they've just said they set out the reasons at 1.3.
Well, if they don't set out the reasons, all they do is assume that he's wrong. They don't try and set aside his decision. They don't say that that decision was wrong.
Okay.
They don't say what he failed to take into account. All they're trying to do is have a rehearing of that decision. What they don't do is identify what he left out of consideration in that decision and what he took into consideration wrongly.
Okay. Right.
Now, just to deal very briefly with what was the evidence before the judge, there was essentially no explanation at all for the delay in bringing the claim in the Dubai courts after a year. My learned friend took you to page 109, the witness statement of Mr. Kishore, and paragraph 32. Now, essentially, the only explanation was that it was thought that nullification claim was a claim under UAE law and should be in the Dubai courts. This was why the nullification claim was raised but not developed in the original defence. Well, that is not the case. It was not raised in the original defence at all.
Yeah.
And as the learned judge mentions in his reasons, OIC didn't even give notice of this potential action throughout the year that they waited to bring the Dubai claim. The application, the Dubai claim was issued without any notice at all. And in those circumstances, the judge was perfectly entitled to take the view that this was a deliberate attempt to achieve delay through an abusive process.
Yeah.
Which is what he did find. And as I've set out clearly in my skeleton argument, the judge did not simply rely on the findings of the JJC. The JJC itself had a high-powered panel. This is not the consideration on a whim that is that it seems to be implied that Miss Justice Field just followed something which he shouldn't. There's an extremely high-powered panel, including the Chief Justice of the Court of Appeal of Dubai, the Chief Justice of the Court of First Instance of Dubai, very similar of the DISC. In fact, Justice Sir Richard Field, notwithstanding that he's an extremely experienced High Court judge, was the junior member of that panel of 7.
Yep.
And as I've said in my skeleton, he did simply accept it. He saw no reason, nothing had been put before him to disagree with their view.
Yeah.
He wasn't simply being swayed by their obiter comment. Again, when it comes to security, my learned friend tries to say that he was wrong to ascribe blame. My lord, you have given contrary indications as to where the blame might lie in any event, or agreed with Justice Sir Richard Field. But my learned friend has not been able to point to anything that the learned judge left out of consideration. He's just saying, I want you to reweigh in the balance these factors.
Yeah.
And essentially that is entirely what this entire appeal is simply an invitation to the court to reweigh factors that the judge clearly took into account. As I've set out in my skeleton, I've taken your lordship to the paragraphs where he deals with all these matters. It is simply an attempt to get a reweighing in the balance. And as the authorities that I've set out in my skeleton make clear, that is simply illegitimate. That is not the purpose of this true appeal. My lord, unless there's anything on which I can particularly assist you otherwise, my skeleton argument says it all.
Yes, well, thank you very much.
Dismiss the application.
Thank you very much.
My lord, can I just come back on one point, which is the public policy, public order point?
Yeah.
We don't rely on that in terms of there being some other compelling ground for appeal. We rely on that because we make the point that the nullity point has real force and which is obviously relevant not only to its merits but also to the balancing exercise as to what OIC loses if that defence, if that strong defence is essentially not allowed to be added in. We do say too that because it's a point of public policy, it is substantially a point of law and therefore could be decided relatively easily. But we also refer to the fixed sense decision, which is a decision only of last month, so after were lodged, which suggests that issues of public policy should in principle be ventilated with full argument at trial. So we make all of those, none of which are particularly relevant to the other compelling grounds for appeal.
Yes, thank you. Thank you very much. Well, having read the skeleton arguments and heard helpful submissions, I'm going to give my decision now. It seems to me that nothing is to be gained by taking it away and giving a reserved decision. This is an oral hearing. This should be recorded and then typed up. This is an oral hearing of an application for permission to appeal the order of Justice Sir Richard Field, dated the 4th of October 2020, refusing the defendant's application to amend their defence and to lodge a counterclaim. Other aspects of his order are not in dispute. Sir Richard Field himself refused an application for permission to appeal against that order, and this is in effect a renewed application, an oral application for permission. Yeah, I can. Where did I break off?
My lord, you said that this was a renewed oral application for permission.
Right, that wasn't very good then. Right, I'll carry on. This is in effect a renewed oral application for permission to appeal against that order. The test for appeal is set out in RDC 44.19, and the permission to appeal may only be given where the lower court or the appeal court considers that one, the appeal would have a real prospect of success, or two, there is some other compelling reason why the appeal should be heard. The real prospect of success test has been interpreted in a number of cases to mean that there must be a realistic prospect of success rather than a mere factual one. But of course, the prospect of success need not be compelling or other than realistic. It was argued for the claimant that the defendant in its skeleton argument and in its grounds of appeal had not identified any error of law, but was simply seeking a rehearing of the matter. I'm not persuaded that this is correct. Applying the test set out in RDC 44.19, I'm persuaded, though only just persuaded, first, that it is arguable that the judge gave insufficient weight to the importance of the amendment. In other words, a complete defense to a claim for $36 million odd. Secondly, that it is arguable that the judge erred in his assessment of culpability for some parts, at least, of the delay in raising the issue in these proceedings. And third, that it is arguable that the judge placed too much weight on the question of culpability for delay, as he saw it, as opposed to the question of what prejudice, if any, would be suffered by the claimant if the amendment was allowed. As I say, it seems to me that these points are at least arguable to the extent of giving rise to realistic prospects of success, even if not higher than that. For those reasons, I propose to grant permission to appeal, and I will do so. The only question now is the question of costs, and I'd have thought the appropriate order, subject to hearing argument, would be costs in the appeal. Does anyone want to say anything about that?
My Lord, no, I don't think we would have. I think that's the appropriate order.
My Lord, we'd concur.
Very well. I shall grant permission to appeal, and the order for costs will be costs in the appeal.
Agree.
Thank you very much. I'm sorry about the inconvenience to everyone of having it dealt with by telephone with no pictures, but something's gone wrong with the Wi-Fi at home, and I'll have to fix that now. Thank you very much.
Thank you.
Thank you.